So, just explain to me exactly how CLE should work in your view in Nigeria. What is wrong with CLE for lawyers right now, and what should be done? Just in very simple terms, what if you were asked to fix CLE or introduce a CLE system for Nigeria, what would you do? How would it work?
First, it's going to be mandatory for every licensed lawyer in Nigeria to do a specified number of hours a year, because a lot of lawyers are now reading, all the knowledge base they have is based on whatever was done in their law school, in their faculties of law, and you can't rely on those because the standards are not the same. So first of all, it's got to be mandatory. That's number one. Number two, it has to be structured in such a way that a lawyer in practice in Nigeria or in the industry, because even if you're working for the ministry, you're in practice, must have a number of CLE hours in a year to keep that license going. That's number one. And a number of very highly trained bodies that are available.
When you mean bodies, are you talking about private agencies, private training providers?
Yes.
That are licensed?
Yes.
By who?
Okay, there are some very good training providers that are available around. There are lawyers in Nigeria, and some of them, the better ones, actually have foreign exposures, so that they are coming from a perspective where these things are routine. You know, so they are certified by the Nigerian Bar Association to go out throughout the whole country and conduct this training. The reason to get these private providers and outsiders is to ensure that it's outside the control of the NBA.
Why is that necessary?
Well, for standards, because a private provider does not want to risk his reputation by giving somebody a certificate of having attended classes when there's no evidence that he did. Besides, these things are going to be paid for, so he is obligated to provide them.
Who's paying?
The lawyers are paying. The lawyers are paying because they're getting the direct benefit.
Okay.
And they're paying, and they're also getting the credit hours allotted depending on the classes they take. At least the major law classes in an adversarial system, a common law system, about 6 classes supposed to be available throughout the year, mandatorily available to all the lawyers in practice. It must be available instead of all the squabbles by the MBA leadership about conferences and whatever. Give the lawyers who are paying these bills the real upgraded continuing legal education to improve their skills. A lawyer who has a 3-hour CLE in contract drafting is a lot better than somebody who is in practice and never had any, or is basing all he knows about contract from whatever the professor did in universities. Where I can assure you, as a lawyer in practice for 35 years, nothing is done in these faculties to show law students how to draft contracts, why the clauses are important, and enforcement. Sometimes many of the necessary aspects of these areas are not even covered, and no consequences are allotted. So it's the CLE that is supposed to fill in the gaps.
So tell us some of your experience in this area. You've done a lot of work in terms of CLE for lawyers in America where you've practiced.
Yes.
Can you share some personal experiences about how that worked or how it works over there?
Very simple. I'm licensed in the state of California, and California has had an organized bar since 1927. America as a whole has 50 state bars plus Washington, D.C. That's why we say 50 plus 1. And the bar exams are taken twice a year, one in February and the other one in July. Some of those certified ones like us do CLEs for practicing lawyers. And then we also do bar preparations for lawyers who are taking the state bar exams. Because in the United States, bar exams are state-based. So if you want to practice law in California or Washington, D.C. or New York, you have to go to New York and take their state bar. Of course, they have the federal component, but your license is going to be a state license. So when you go to these CLE classes or bar preparation classes, there are so many companies. Like I said again, the model is private. Private. You have so many Barbary, you have so many PMBR.
These are private providers.
Private providers who do it year in, year out.
Yeah.
That's number one. Number two, the ones that do the CLEs for practicing attorneys are licensed attorneys in good standing in their various states. Those are
individuals?
Individuals.
Okay.
Or corporations, because sometimes there are corporations, because there are some lawyers in practice who do it full time. In other words, they go around all the 36 states, all the 50 states plus one, and do these CLE classes or bar preparation classes. In fact, I had worked with somebody who had 33 state licenses going around, because that's what he does full time. To show students that it can be done, that passing the bar exam that is fully certified, he has 33 licenses in 33 states, going around teaching them. Because in the United States, again, the federal law system that you use is standard for all the 50 states plus one. But the state laws may vary. For example, if you take the California State Bar examination, you don't need to do federal income tax. You don't need to do tax law. But if you do it in Minnesota, you may, or New York. If you do California State Bar examination, you must do community property. But if you're in, there are some states that are not community property states. You don't have to. In the California State Bar examination, there's a section on questions can come from community property. But the core 6 classes are compulsory on all the 50 states plus one. Contracts, torts, constitutional law, evidence, criminal law, criminal procedure, and so on and so forth. They are all compulsory. The 6 core common law classes are universal for all the 50 states plus one. So you go over there. If you're doing the CLE, for example, review in contract or torts or constitutional law, first of all, you must cover the curriculum. Review. You must answer all the questions. You must upgrade the individual lawyer from what he knew. There has to be, because these things improve all the time.
It's going to be provable.
Very provable. You have materials that are approved. You have your teaching skills. You have your workshops, all within the CLE ambit. So that they go through this 5-day, 6-day, whatever workshop. At the end, they do the workshops, they go home with the materials, and then they now earn the certificate and the number of hours they have earned. So that they file those number of hours with the state bars, because state bars mandatorily require you to have so many number of CLE hours to keep your license going. That's why I said India.
That's where the problem is here.
Yes.
There is no incentive.
There's no incentive and there's no mandatory.
That's what I'm saying.
Requirement.
There's no reason why you must do it.
No, that's why the lawyers don't bother. Because nobody says you must keep your license up to date. And that's why the standards are all over the place in Nigeria.
Yeah.
A lot of lawyers don't know anything, but they are lawyers. There's no requirement for them to even know anything.
You don't have to be up to date.
No.
That's one of the...
In fact, I had an experience here whereby I was in a law firm, and I found out to my shock that the lawyers, very senior lawyers, are still using the 2004 Evidence Act. I actually pulled them out from the shelves and showed the senior counsel, are you still using the 2004 Evidence Act that is already no more operational in Nigeria? He said yes. I said, no, you need to use the 2011 current Evidence Act, 2011. And actually brought my own copy and left it with the law firm. But if you have a continuing legal education class, that will have been taken care of. First of all, you go to an evidence CLE class, the updated copies will be given to everybody as part of the course.
Yeah.
And they will now be seeing the differences between the old one that the new law has tried to improve. For example, with the Evidence Act, for example, you have the new Section 84 on electronic evidence that has been creating problems, judges throughout the country, all over the place. Okay, lawyers in Nigeria ought to have a complete workshop
on the new law.
On the new law. There are other sections.
How does that relate also to the? How does that relate to Sorry. How does that relate to the issue of the Criminal Procedure Act, the ACJA? Because there's been a lot of talk about lawyers not being prepared beforehand, and the change was a little bit rancorous. You got some thoughts on that?
Yes, you see, the ACJA was one of those acts that was rushed, as far as I'm concerned, was rushed and signed into law by President Abela Jonathan in 2015. There are others. And when this thing was brought to my attention, it was by accident. The Nigerian Bar Association was having a national conference in Abuja here, in the ICCCN Center.
What year was that?
I think it was 2015.
Okay.
Either 2014, 2015. So, and I was watching TV because I was at home sick with the flu. And all these big lawyers were coming on TV, extolling the wonderful aspects of the ACJA 2015 and everything, saying it's the best thing that happened to Nigeria. So I became curious. So I hopped into a taxi, went to ICC Center and picked up a copy. When I opened it, it had 245 sections. From page 1, that was a problem. By the time I read through the whole sections, I saw that ACJA was a disaster story. So many terrible situations, a lot of verbosity, a lot of conflict with the Constitution, the ground norm, a lot of contradictions, a lot of imprecisions, so many things that are so bad with the ACJA but nobody bothered to read them. Nobody bothered to review them, So I wrote on my online column criticizing the ACJA. In fact, in a lecture at the Nigerian Human Rights Commission, a lot of very senior lawyers, senior advocates of Nigeria attacked me for daring to criticize the ACJA. In fact, one of them, a senior advocate of Nigeria, I won't mention his name, asked me, so all the big agencies in Nigeria, all the professors of law, all the senior advocates of Nigeria, the NJI, the Nigerian Institute of Advanced Legal Studies, all the committees of the Senate and the House, reviewed this thing and I thought it was wonderful. Why you? That's what he told me. He wasn't interested in the sections I was citing to him about the specific provisions in Section 12, in Section 18, for example, whereby the Constitution, Section 351C, said that the criminal standard in Nigeria, that is, I'm talking about the Nigerian Constitution, 1999, is what they call the reasonable suspicion standard. Very low threshold. Reasonable. In other words, the police officer can arrest somebody when there's a reasonable suspicion that he has committed a crime, or is about to commit a crime. But under ACJA in 2015, an act of the National Assembly, Section 18 has over 20 different standards for the same police conduct. Which one do you follow? It has reasonable suspicion, it has reasonably suspects, it has probable cause, the standard in the United States, and so many other highfalutin, confusing standards. And the question is, which one do you follow? I started Section 18, I sectioned Section 44 and Section 148 that told them that the police has a right to arrest Nigerian citizens unenforced arrest warrant anytime, anywhere, including public holidays and any time of the day or night. I started out with problems. I was ignored, I was criticized, some of them were so angry, I won't mention their names. However, when the President Buhari administration used the same sections to now arrest Nigerian judges
and rape judges,
break into their homes as authorized by the ACJA, arrest them under reasonable suspicion, the same group of lawyers were now screaming blue murder, that President Buhari was autocratic, breaching the rule of law, destroying the Nigerian legal system, destroying the Nigerian judiciary, and so on and so on. Actually, it was after that I started receiving calls from people who initially, when I was screaming about the obnoxious sections in this ACJA, were calling me names, were now calling me back to now come and speak to their various groups about the same ACJA that they were extolling 2 years earlier. It was only after the President Buhari administration used the same sections, all the sections are named, right there to arrest these judges. But nobody, when I now went back to, it was kind of an interesting thing. I had to remind the judges, all the senior lawyers, that I told you so, which nobody ever wants to be in a position to say, I told you so, that these sections are horrible. And Buhari, that's exactly what they use. They say, oh, but the DSS is, I said, no, look at section 494. That is the definition section of the ACJA. The DSS is one of the police agencies that can do it. Because the initial problem was that the DSS have no business in enforcing the laws of Nigeria. I said, well, you can only say that if you didn't read the definition section, section 494 of the ACJA. It mentioned all, it just gave you, it's an umbrella. In fact, the customs service
can do that.
Or can do that. But these things were ignored when I mentioned them. That Buhari or the DSS did not break any law. They just applied
what you gave them.
They just used the instruments, the blunt instruments you gave them in the ACJ, which is why I was criticizing them in the first place. It's a blunt instrument, I agree, but it's the law. Okay, guess what? After all the shouting and everything about how draconian the Buhari administration was, have they made any effort to do something about the ACJ? No, they haven't. They haven't. But the ACJA should be a very powerful CLE subject for lawyers in Nigeria, so that every single lawyer in the 36 states needs to attend a mandatory CLE on the ACJA. By the way, there are others. The cybercrime is another one too, another draconian one too. The so-called, all of them signed by President Jonathan, I must tell you. The Cybercrime and Prohibition Act is 2015 too, signed by Jonathan. The other one is what they call the Offenses Against the Person Act, is 2015 too.
What about the Freedom of Information Act?
Well, that one too. But the reason these ones are particularly important is because it involves criminal conduct, whereby the state has power to now abridge the liberty of the individual. That's why they are different from the Freedom of Information Act. You don't run any criminal risk in the Freedom of Information. The government may refuse to give you the information you want. But under cybercrime, for example, nobody bothers to look at section 24. I reviewed that too, and I told them, watch out for what this thing is done. The cybercrime is not, I know the title is it gives you the impression that they're going to use it to find internet kidnapping and all that kind. No, they're using it to destroy section 39 of the Constitution, which is the freedom of expression. All the enforcement so far with the cybercrime is going to arrest somebody for what they say or what they write on the blog, or the arrest. Very recently, a pharmacist in Ibadan in fact, the daughter of the former governor Olunloye of Oyo State, was picked up in Ibadan for what she wrote in her blog, accusing a pastor in Port Harcourt, Rivers State, of some objectionable activity. She was picked up in Ibadan and transported all the way to Port Harcourt to be locked up under cybercrime for what she wrote, ignoring Section 39 of our Constitution that says freedom of expression as a fundamental right. You see what I'm saying? So, under Section 24 of the cybercrime, like I said, 2015, every lawyer in the country needs to understand that fact so that the only way for them to understand is to go through a CLE. And then everybody has a copy of the cybercrime. You go through the sections.
Another important area, because
Yes.
don't forget that we are dealing with business law in this group.
Yes.
And that's where our major interest lies.
Yes.
We're particularly interested in areas where some of these laws that you're talking about interface with the conduct of business,
Yes.
doing business in this country.
Yes.
Cybercrime and the implications that will have
It has a
on
lot to do with
organizations
business too.
and business
Yes.
as well.
Yes.
Also, the whole issue concerning admissibility of
Yes.
electronic evidence
Yes.
is an area that is of particular interest
Yes.
to us.
Yes.
How have we performed in those areas? Do you flag up any issues there, or that should be of concern?
Yes. First of all, like I said before, the Evidence Act 2011, Nigerian Evidence Act 2011 is the current Evidence Act, an Act of National Assembly. It has Section 84, which is right there, the admissibility of electronic evidence. Recently, a judge, Justice Alaba Ajeleye, published a really wonderful book, in fact, the only book on that section alone, on the conditions for the admissibility of electronic evidence. It's in print, it's a new book, it's the only one in the whole country, analyzing all the standards that must be followed and the understanding of what an administrative or what an electronic evidence is referred to, the email, the text messages, and so on and so forth. Guess what? Most of your lawyers in your country,
In our country, sir.
in our country,
Thank you.
in Nigeria,
Yes.
are analog. They are not even up to date in the world that is moving so fast. So that's why I argue that every lawyer in Nigeria must mandatorily go through training in that electronic evidence, the procedure for. There's no trial, I can dare you, there's no trial now in court that doesn't involve bank transfers these days are electronic. Most businesses are done through phones, texts, emails, WhatsApp. So all these things involve
Even internal management of organizations.
even internal management of organization,
Yes.
every banking situation, every insurance situation, even government.
And record keeping in there.
Record keeping involves computers, and if it involves computers, you're now dealing with electronic. To have Nigerian lawyers practicing
Without.
in the 21st century without a CLE on admissibility of electronic evidence, Section 84, or the whole Act itself, Nigerian Evidence Act 2011, is shocking. It's horrible. It's very retrogressive, given how the world is moving forward. Nigeria can be.
But I don't want to. The purpose of this discussion is not to lay blame or to so much. We don't want to apportion blame. We don't want to be unduly critical of the bar or the law schools or the system as a whole. Don't lawyers themselves need to have a sense of responsibility for their own development as professionals? I mean,
You would think.
what is the way forward?
You would think the MBA will be thinking in that direction, but the MBA, as I see it, from what I read, are just fighting among themselves. Very dysfunctional. I read about some state chairman being removed, and all kind of fights about leaving the important business of improving the lot of lawyers and their knowledge base and technical skills undone. As far as I'm concerned, moving forward, we should be, as members of the MBA and the MBA as a whole, business section or whatever section, gotta move on with the business of improving the practice.
Developing lawyers. Building capacity.
And as far as I'm concerned, you cannot have a bar association, you cannot have a rigorous law practice, you can't really have a law, a bar association, or the judiciary for that matter. After all, the judges are lawyers too, are members of the bar, without a continuous legal education in some of these areas is very, very critical. I went with Justice Ajileye to present his book at the NJI on 3 occasions to all the magistrates in the country, to all the judges, both at the federal, at the High Court level and the Court of Appeals. For me, you sit down and listen to some of the questions, you move from shock to confusion.
And to seizure.
Because you see judges and senior magistrates asking questions that will shock you. And these are the people who make decisions and look at these cases every day, but they don't have a clue. In fact, my own advice is that even the CLE will include judges too, mandatorily. After all, judges are lawyers, and they need to improve on their skills, because if they don't have the skills, how will their judgments look like? Which is exactly why I'm one of those who criticize many of the judgments, which is why you have all kinds of decisions. For example, you hear some federal judges overruling the decision of their fellow High Court judges. That's not done, because they are on the same level. Okay, but if they don't have a continuing legal education where these things are going to be spelled out very, very clearly, and there are so many highly qualified technical private providers that are available and willing to provide the skills, to provide these workshops, to provide the CLEs, and improve the system. Are we willing to do it? And that's the big question.
Thank you so much.
Thank you so much.